Hello, hello. day before yesterday evening, an order has been signed by the Secretary for the Municipal Council. It was not served to me. It was pasted today morning. And today is the deadline given for demolition of my shop room. Particularly when this is for the fourth time I am coming before this court. In the past 3 times, order of demolition were passed, this court set aside. So there is an extreme urgency because today is the deadline. Today only pasted the order and it carries a date of 29th. It was never served to me. Pasted and I have been informed that today it will be demolished. In a haste manner. There are High Court's orders said that you have to give a hearing opportunity, reasonable opportunity to be given, audio part needs to be complied with, then an order to be passed. 3 orders of this court. Ignoring these 3 orders, in a haste manner, the orders will pass. Not leave be granted to move the state application because under appellate sites for not Rule 27, 48 hours is a mandate. If I could show urgency and Monarch can dispense with it, leave has to be granted so that I can move this matter in view of extreme urgency involved. Monarch carries both. Monarch, both are not. There are courts order, High Court's order.
Yes, senior is there.
I can mention anywhere, but the convention is anywhere. If Monarch sits singly, Monarch is senior to this court. If Monarch sits division, Monarch is senior. No, kindly grant. Monarch, I'm grateful.
Leave is granted.
Monarch, I'm grateful. Any other mention? This matter has been filed, but I am told by the department this will not be listed.
Why?
I am wondering, Lashu, why this has happened. Let this matter be brought in list. If the officer have any objection, he can endorse in the petition. This is a procedure. On this count, I have not been given a number.
Look into why it has been done.
But what has happened in the fact, I'll tell you. My daughter was found hanging in a room. UDFI was initiated. Administrative inquiry was done. Ultimately, police agency submitted the report before the subdivision magistrate that it's a case of suicide. Being agreed with this aspect, I filed a petition. Identical matter in the past before her ladyship, Honorable Justice Indira Banerjee removed it. It was in the form of a petition under Article 226. It was entertained, it was allowed also. CBI was directed to hold an inquiry. The inquiry was snatched away from the local police, it was relegated to the CBI inquiry. I want an independent inquiry to be made. I'll show the materials, but this has to be registered first. This has to be brought in the list. If the office have any objection.
Any UD case has started?
Yes.
That you lodge and any complaint?
The complaint, on my basis, the complaint was lodged.
So whether based on your complaint, the UD case from UD case to police case has not been registered.
Action in this petition. I have lost faith in the local police, and the material which I have announced in the petition, Lord would say it's not a case of suicide. It's an alternate case of murder.
Have you got the PM report?
Everything is part of the petition. Everything.
Hey, why tell him to register it?
Bring in the list.
Huh? Tell him to. Who has got the authority of an official cannot say that whether it would be accepted or not.
No, appellate's rule says if there is any objection in the writ petition at the backside, it's written. On this count, the court would consider it.
No, that is technical aspect. Stamp properly not giving, such and such party has not been properly made. But whether it would be entertained or not, let it be in our domain.
Mr. Mani Babu, being the head of the office, I am told by.
Yeah, ask them. If he feels any difficulty, you ask him to come to me.
Blair.
Yes, all. Yes. So next week, not today.
That to be giving us map because our everything is there. They have to take instruction and come back. That is the last order. Just to take instruction whether map can be provided or not.
Yes.
That was the last order. So maybe they have taken the instruction whether. So let it be possible.
Okay, possible.
For the petitioner.
Same thing. No, for the same purpose. Seeking map or anything. Oh. Passover means weekend, Friday, you want Passover?
It's in the next 4 years to come.
Huh?
Come back.
Oh, okay. Till the rising hand.
I'm on the prediction law.
Yes.
Number 3, 4 and 5. What is it? That is not it. Case under section 128, which was
Oh,
Rejected.
who is the other side?
Arul Prashant sir is appearing.
Where is he? Mr. Dolly Sarkar submits her senior counsel Arun Prakash, who is to argue this matter, is out of state.
It will on 5th, my lord. Mr. Arul Prashant is appearing, he requested me to take time to.
Oh,
Lordship, let it be on 5th as in for final argument, Lordship. Because your Lordship has heard this matter, Lordship. Let it be fixed on 5th as a final argument.
okay.
Because the petitioner is without any penny for last 5 years, Lordship.
Three matters are same.
Yes, Lordship. Identical matters, Lordship.
Hey, three matters are same. So you will send only one. If you send, if you want to send the year, you will send only one. Yes.
I'm always Lordship, grateful, Lordship.
Item 6, CRR 1,125. But item 6, I am appearing for the petitioner. Undertake to serve the copy to my landlord. Let it come on Wednesday. I was under the impression that it was served, but my office was not served.
Okay, so when you will be?
Sir, Wednesday, 6 and 7.
6. Okay.
Item number 6 and 7.
6. 6 and 7. Only 6. Now, the date is fixed on 6 February. 5th. Okay, 5th.
Both the matters.
Both 6 and 7, 5th February.
Item 8, Lord, it can be taken up. Item 8 can be taken up. I have already served to my landlord, but very short issue is involved.
Yes.
My lord, the issue is, my lord, a case was registered under section 147, 149, 342, 324, 504, 506 of the Indian Penal Code. Now, the allegation is that this accused petitioner, along with other accused persons, assaulted the victim, due to which he sustained injury. Ultimately, my lord, that trial culminated into conviction, whereby I have been convicted for a period of 2 months. 2 months. Which, along with other accused person, I also challenged it before the appellate court. Appellate court did not interfere with the finding of the trial. Now, I have only one argument. First is, Your Honor, the victim nowhere in her deposition made a specific allegation against me. There were altogether 6 accused persons. That 4 and 5, they are relative. I am not relative to them. But since I was also present there, I was also arrayed as an accused. We were carrying work in the paddy field. Now, Your Honor, in PW1, in none of her, in her deposition, not a single word was added, whereby she said that this part, my lord, common intention is altogether different aspect. But here, there was some tussle between that two families. Now, I was there. So, the specific act which was played by me, it is not there in the statement of the victim. Now, by.
So again, you are inviting us to reappreciate the
No,
evidence.
I am not. I am not.
Actually, it is told, but actually we are invited to
No, no,
look
no.
into the
I
evidence.
have 2 arguments, Your Honor. This is first part of.
So
the-
your presence in the spot or in the
It's not
place, it is proved.
Presence, I am not denying. I say that.
Yes. Now 34 or 149 was invoked.
149 was invoked.
Was 149 was invoked.
My only, on merit, my only submission is that whatever statement or whatever the injuries caused to the victim, nobody else can improve that. Now, victim nowhere stated what is the specific allegation against me. Therefore, I say that, so far as I am concerned, the case is not proved against me. This is on merit. I am making a submission. Second
In
submission.
case of, you know very well better than me, in case of unlawful assembly or here common object, common intention here, overt act of every accused person is not required.
Not required. 34, Your Honor. My second argument.
Yes.
I will try to pursue, Your Honor, my lord, with regard to my second argument. My lord, this punishment is for 2 months only. probation of offenders act, it can be considered. I am a lady presently aged about 48, 50 years. 2 month imprisonment was given. Now, that aspect may be considered. There are judgments of our court. My lord, please, I can place, because in several other matters where I appeared, this court accepted my argument and given. Section 4 perhaps of the provision of.
So what is your submission? You are directed to surrender within 1 month when?
My lord,
Order dated
order dated August, my lord.
August.
August. My
So
lord,
1 month has already been expired.
My lord, I have sought for a stay of the order because they have applied immediately, but they received the copy. My client received the copy in the month of November. My lord will get it from the original order copy wherein the date of application is there. When the appeal was dismissed, same day the application was made, but they received it because it is from Mayabandar. Received in the month of November. Thereafter, accused petitioner came here. I prefer this revision.
Yes, Mr. Kormakar.
There was a direction to surrender within a month.
So that I have sought for.
That was
stay.
not complied first. Second thing regarding deposition, again I compelled to submit before this lordship already desired that concurrent finding, everything has been discussed. On merit, we have to see whether irregularity or illegal order have been passed. In this revision application that cannot be taken, even though punishment is 2 months lordship, but everything has been proved before the trial court.
I am
The
not
first
on merit. I am not on
Yes.
merit.
Okay, trial court probation, that part, 360, page.
Discussed or not.
59, not discussed. Not discussed. Page 59. Of the, my lord, the running page, I don't know, my lord, but the judgment internal page 59.
Oh, internal page 59, yes.
There is no discussion at all.
Okay, yeah. Never, can never. Although, huh? This revision challenged the order dated, it challenged the judgment. Dated 7th September 2022 passed. No, sorry.
Yes, my lord.
No, appeal, first appeal. 23rd August 2024. Passed by the learned additional session judge, North and Middle Andaman Mayabandar in criminal appeal number 11 of 2023, and the order dated 7th September 2022 passed by the judicial magistrate first class, North and Middle Andaman District Mayabandar in GR case number 283 of 2011. Stop. By the order dated 7th September 2022, the present petitioner was convicted and sentenced to and sentenced as follows. If it is oh. was sentence as follows, right, sentence as follows. One, Roman 1, for the offense punishable under section 324 IPC, 1 Indian Penal Code in short IPC, then IPC, petitioner was sentenced to undergo simple imprisonment for 2 months. No, for 6 months. For 324. Next, for the commission of offense punishable under section 147 IPC, simple imprisonment for 2 months. And additionally, the convicts were also sentenced to pay fine of rupees 500 for each of the offences punishable under section 342, 504 and 506 of the IPC. So, with a further direction that the sentence of imprisonment shall run concurrently, and in default of payment of fines, a substantive sentence of imprisonment was imposed upon the petitioner to suffer further simple imprisonment for 15 days. And the sentence of imprisonment in the event of default of payment of fine was directed to run consecutively. Stop. Mr. Kumar, an advocate representing the petitioner, submits that the judgment of conviction and order judgment of conviction is totally perverse and based on no evidence so as the present petitioner is concerned. He submits that there is no evidence regarding any overt act allegedly done by the petitioner which contributed the entire offense. He further submits that here the petitioner has been awarded, has been sentenced of imprisonment for 2 months only. But the learned court below had never considered the aspect as to whether the benefit under section 360 of the Code of Criminal Procedure could have been extended in his favor or not. He submits that due to these irregularities, these 2 irregularities was raised before the learned appellate court, but the learned appellate court glossed over the same and no finding has been returned on this issue, which warrant interference of both the orders under challenge in this division. Stop. Mr. Karmakar, learned advocate, because appearing for the respondent, submits that the petitioners have challenged the concurrent finding of conviction and order of sentence. He submits that petitioner cannot invite the court to reappreciate the evidence. And he asserts that prosecution brought sufficient evidence which led the learned trial court to hold the petitioner as guilty and to pass order of sentence. And the appeal court also upheld the said judgment of conviction and order of sentence. He submits that since the offense is heinous, considering the gravity of the offense, the learned court below has rightly did not extend the benefit of 360 of the code.
Lordship, one submission.
And
Regarding provision, that is observation is there.
trial court,
Right. Which page? 57.
50,
Sir,
Finding is there.
59,
57.
57.
Second paragraph. Considering the nature of the offences for
Oh.
which the accused person have been convicted, I do not think that it would be fit case to extend them the benefit of probation of offender act. It can be gathered from the record that all the convicted middle-aged persons and mature enough to explain the severity of their actions and its consequences. It is also noticed that instead of offering any explanation for their conduct, the convicts have actually presented denial in respect of prosecution version of the incident, which is being examined by the court under section 313 CRPC.
No, these cannot be the consideration. In 313, all the accused will deny their allegation, whatever allegation and whatever statements were made. The consideration will be-
In the circumstances,
But there is no finding.
in Kumar's submission, Mr. Kumar submit that by passing one cryptic order, ঠিক আছে, it was by passing on cryptic order in casual and cavalier manner, the court observed that the petitioner was not entitled to get that it was not a fit case to extend benefit of the probation of offender acts, ঠিক আছে, in respect of the accused person, including the petitioner also.
And then their 313 has denied. This is what the court's finding was there. 313 CRPC, they have denied whether this can be a consideration for granting a person on probation. His antecedent ought to be considered, his status in the society ought to be considered, and what would be the effect of such consideration?
And denial of prosecution version by the accused person during his examination under section 313 CRPC was also based in decline the benefits of provenance of offenders act. He submits that right to remain silent during the criminal trial is a precious right granted to an accused person under Indian criminal jurisprudence. So, for making such denial, one benefit which as legislature has been extended cannot be snatched away. ঠিক আছে, stop. Had the learned advocate peruse the orders under challenge in this year, stop. Admittedly, a revision cannot be converted to a second appeal, and a court cannot invite it to reappreciate the evidence again unless there is the orders passed by the learned trial court is perverse, or there is any procedural irregularity which eventually resulted in miscarriage of justice. However, here considering the evidence, however, only for the limited purpose to determine whether the trial court decision so far this petitioner is concerned is perverse or not, I examined the evidence deeply and it is found that by cryptic order, the learned trial court has refused to extend the benefit of Probation of Offenders Act in favor of the petitioner, though order of sentence say the imprisonment for only 2 months was imposed upon the petitioner, who is a middle-aged lady. Considering all these aspects, I,
6 months.
huh?
6 months punishment.
Oh, 6 months, yes.
6 months.
6 months. 6 months. Considering all these aspects and having heard having considered the submission made on behalf of the respective parties, I am of the view that a good arguable case has been made out in this revision, and the issue raised in this revision need to be addressed. And unless the interim order as paid for is granted, the petitioner will suffer irreversible injury. Stop. Consequently, the portion of the order whereby the learned appellate court directed the petitioner to surrender before the learned trial court, and the order of sentence passed by the learned trial court are stayed, stopped, or stayed. Acha, copy has been served. Let the সব যদি রেকর্ডটা ট্রায়াল কোর্টটা চেয়ে বটে নাকি let the trial court record be called for. I'll list the matter. Next circuit.
I am under the record. That will be after a month. That will be interim order.
After a month, you will enjoy interim order for a month.
What I propose, my lord, what has been fallen, my lord has taken pain of it. Let it be disposed of, my lord, in the line. By granting me to.
That trial court record is to be looked into. You are saying based on no evidence. Though I have expressed the settled legal position that when 149 has been invoked, 34 has been invoked, it is not material that everyone is to
Yes.
overturn.
Mind will do.
Yes, meeting of mind. List the matter before the next circuit bench for final hearing, subject to its convenience. Next.
Grateful.
One sir.
Item 9, the 3 of 125. So civil revision at the behest of defendant number 1 of pending suit.
Yes. Why? What has happened?
Your Lordship, I am for the.
How many respondents?
So I may be permitted to refer with their status in the suit.
There is another respondent. Oh, yes. Yes, what had happened? Tell me.
So what has happened, just a background actually. Now, it's not about specific performance filed by plaintiff. I'm the defendant number 1. The suit plan is duly recorded in the name of defendant number 1, being the petitioner. It was a case of the plaintiff before the court below that plaintiff, defendant number 1, on the date of a power of attorney holder, deed, asked defendant number 2, for whom this madam appears, to sell the land. Defendant number 2, exercising the power, have agreed to convey suit plan in terms of the sale agreement in question in favor of plaintiff. When it was not done, suit came to be filed. In aid with the suit, they filed an injunction application. The trial court held that since consideration has been passed on, interim protection and disposal of the suit has been granted. I challenge the order in appeal. Order 43 is the first remedy. I lost. Now, it's an application under Article 227. Now, if there is a miscarriage of justice, or if the orders are such which shock the conscience of this honorable court, even under Article 227, the court can go into, can look into all these aspects. There are judgments of Supreme Court. But neither the court below nor first appellate court recorded any satisfaction based on the material on record that any single penny was paid to defendant number 1 by the so-called power of attorney holder defendant number 2, because plaintiff and defendant number 2 are close relatives. And even if I go with the material on record, Lord would see, I'll show that paper, the deed of power of attorney. But it was not an authorized document giving the defendant number 1 to convey the land. It's for a limited purpose to some auxiliary works. I'll show that. And Lord, the sale consideration, if because it's a hand in glove of case in between plaintiff and defendant number 2. Defendant number 2 says, I received the money from plaintiff. Then there has to be material showing that defendant number 1 was paid with, because the suit line is in defendant number 1. But I am residing in Kerala. The plaintiff, the defendant number 1 is residing in Kerala. So kindly also show the impute order first.
Yeah. Last page.
Last page I have not agitated. I'll just take, or rather I'll bother this court to
Misappeal, you will show me the misappeal order.
before Wakala comes.
Yes.
Judgment dated
It's the last annexure, yeah.
January 2025. I'm just phrasing it.
Yes.
The misappeal has been preferred against impugn order number 7 dated 26/12/2024 passed by the learned Joint Civil Judge Civil Division Portland in other suit number 144 of 2024, by which the learned judge allowed the petition filed by the plaintiff under order 39 rule 1 and 2 of the CPC, restraining defendant number 1 from transferring or alienating suit property till disposal of the suit property. 2. The facts of the case is that plaintiff, that is respondent number 1, filed a suit against the defendants being other suit number 144 of 2024 for specific performance of sale agreement in respect of land bearing survey number 68, 84, 88, 89, 90, 91 and 1, 91 of the 2, 92 and 93 areas are specified, situated at Brekabad village under Farganj Tehsil, South Andaman. At the time of filing of the said suit, the plaintiff's appellant also filed an application under order 39 rule 1 and 2 praying for injunction. The defendant contested
The said application.
an application by filing their written objection, and after hearing both sides, the court allowed the application filed by the plaintiff / respondent number 1 and restrained the defendant number 1 from transferring or alienating the suit property till disposal of the suit. Being agreed by and dissatisfied with the impugn order, the appellant preferred this instant appeal on the grounds mentioned in the memo of appeal. Points of consideration 1 and 2 block. Whether the impugn order passed by the learned court below suffers from any illegality. Number 2, whether the impugn order passed by the learned lower court below invites any interference by this appellant. Reasons, learned lawyer for the appellant defendant number 1 submitted before this court that he gave power of attorney to the defendant number 2, and the said power of attorney was only to approach before the sub-registrar of the registrar of any other office, court or any authority to inquire about the matter and to obtain relevant documents for the purpose of deed being prepared and also to get the revenue record corrected. And it was not to sale or transfer the property of defendant number 1 appellant to anyone, but defendant number 1 in the light of the said power of attorney executed an agreement of sale in favor of plaintiff. He further submitted that the sister of the defendant number 2 got married with plaintiff, and due to that reason, in spite of having no such power of attorney to transfer the property, the defendant number 1 transferred the same in the name of plaintiff. He pointed out Section 159 of Andaman and Nicobar Islands Land Revenue Land Reforms Regulation 1966 in support of his contention, stating that a person can transfer his land after keeping 2.00 hectares of land in case of occupancy rights in respect of the said land. He also explained about the said occupancy right, that is cultivation right. He further submitted that when the fact of sale came in his knowledge, he lodged one complaint before police in the month of August 2024. Accordingly, he submitted that the learned trial court passed the order of injunction in this case, though plaintiff has no prima facie case, as because right to sale was not given to defendant number 2 by the defendant number 1. Hence, the order passed by the learned trial court is not correct and liable to be set aside. Learned lawyer for the plaintiff of the respondent number 1 submitted before this court that the power of attorney in question dated 23/3/2024 clearly mentioned the provision of sale of property given to the power of attorney holder, that is defend number 2, respond number 2 by the defend number 1, and it has been clearly mentioned in paragraph 2 and 3 of the said power of attorney dated 23/3/2024. She further submitted that on the basis of the said power of attorney, the defend number 2 executed an agreement for sale on 29/4/2024, and this plaintiff public respond number 1 paid 30 lakhs out of 1 crore 10 lakhs, but later the defend number 2 refused to execute the deed of sale. Hence, getting no other alternative, he filed the suit before the trial court as because defend number 1/appellant is trying to sell out the said property to other purchaser, and for that reason he executed another power of attorney dated 5/8/2024, giving power of sale of the said power of attorney holder by cancelling his first power of attorney on 26/7/2024. She further submitted that if we rely on the contention of appellant that section 159 of the said regulation is not applicable in this case, then why he executed second power of attorney for selling the property in question, knowing fully well that this land in question is less than 2 hectares. Hence, the plea of occupancy right under section 159 of the said regulation has been taken only to defend the case by appellants, which has no connection with this case, as because the said section will only be applicable to person who has more than 2 hectares of land, and if he sell the said land, in that case he must retain minimum 2 hectares of land before any such sale. In support of her contention, she referred to one judgment reported in SAT number 6006 of 2014. Accordingly, she prayed before this court to affirm the order of the learned trial court as it does not suffer from any irregularity. Learned lawyer for the respondent number 2 submitted before this court that he acted according to the power of attorney what was given by the appellant of his case in his favor. She further submitted that she executed agreement for sale being a power of attorney holder of appellant on the basis of said power of attorney holder dated 23/3/2024, but could not complete the sale as because appellant revoked the said power of attorney on 26/7/2024 and informed him through a notice. Accordingly, she prayed before this court to pass appropriate order in this case. On perusal of record and hearing submission of learned lawyers of both parties, I find that the appellant admitted that she executed a power of attorney on 23/3/2024, but his plea is that the appellant did not give right of sale to the defendant number 2/respond number 2, and the only power was given to approach to any authority for obtaining relevant documents to the effect that the purpose of deeds being prepared and also to get the revenue records corrected in terms of all dates. When I perused clause 2, 3 and 4 of the said power of attorney, I find that in clause 2 and 3 of the said power of attorney, the right has been given to the defendant number 2 by appellant to execute the sale. At the time of argument, then a lawyer of appellant also admitted that the appellant is a literate lady. If that be so, then it can be presumed prima facie at this stage that she put her signature in the said power of attorney after knowing its contents, and on the basis of the said power of attorney, respond number 2 executed a sale agreement being the agent of appellant. If that be so, then it can be said prima facie that in the said power of attorney, the right of sale the property of appellant was given to respond number 2. However, it is subject matter of trial and the same will be decided during the trial after taking evidence in this case. I also find from the second power of attorney dated 5/8/2024, which was executed by appellant in favor of one other person, namely Abdul Hassan, in which he gave power of to said Abdul Hassan to sell the property. If that be so, then if the injunction order will not be passed in this case, in that case, there is a maximum apprehension that the appellant will transfer the said property to anyone. Hence, at this stage, I find prima facie case in favor of appellant, plaintiff, of the respondent number 1. Hence, the trial court has rightly granted the injunction order in this case, and the question which have been raised from either side will be decided during the trial and not at this stage. I also find that rupees 30 lakhs was accepted by respond number 2, who is the agent of appellant, and if the injunction order will not be granted in this case, then the plaintiff oblique respond number will suffer irreparable loss and balance of convenience, and inconvenience will be in favor of plaintiff. Accordingly, I do not find any ground to interpret with the order passed by the trial court, as it does not suffer from any irregularities. Miss Appeal is dismissed. The order of the court below was affirmed. My lord, the first appellate court went wrong. There it went wrong. My lord, the land in question in these islands, Lord would see it's a classified as occupancy right. I'll show that. If it is an occupancy right, transfer is not permissible with certain exception. The exception would be upon transfer, one has to retain 2 hectares of land. If one maintains this, this is in a case where I admit the case of the plaintiff. It's a point of law I am arguing, not if one transfer it, then one has to maintain 2 hectares of land. In case of occupancy land, I'll show the record entry now. Now kindly turns to page 58. Page 58.
Yes.
Now would see it's a record entry. It's in the name of Anila Soman. Now to find Anila Soman name. Serial number
Yes,
2.
yes.
Now to see the classification, nature of right, third column. Occupancy.
Occupancy, yes.
Every survey numbers. These are the suit lands.
Hmm.
868, 84, next page not 88, 89, 90, all are occupancy. 91 of the 1, 91 of the 2, 92, 93. So total land, not finally turns to page 62.
Yes.
The aggregate area would be, not books is 0.7100 hectare.
Hmm.
Well, let's see the agreement procedure for a while. Let's go with the case of the plaintiff, not with the case of the defendant number 1. Let's say my alleged power of attorney, exercising my authority, have executed the agreement for sale in respect of the entire land, whether it is permissible, whether the plaintiff is entitled to get a degree. What is a prima facie case, Lordship? The plaintiff has to show an arguable case that if she has a good case for trial, he has a good case for trial. Not finally see the agreement in question. I'll show that.
Page
No, just one second. So the agreement starts at page 68.
58.
68.
60. Yes.
So this agreement at page 68 is between plaintiff and defendant number 2. That's Saji Varghese and this. Just one second more. This is not the. Saji Varghese
And Binni Varghese.
Binni Varghese. Yes, I'm grateful. Binni Varghese. Plaintiff and defendant number 2. So kindly see the schedule at page 71. Page 71. I'm purely on question of law. Page 71.
Yes.
Got schedule not to find. Schedule of the property, the suit land. Page 71. No? Not see the entire land. The entire land totaling 0.710 hectare. I could have understand that allegedly agreement for sale is confined to those land and after sale 2 hectares would be maintained. I can understand. Then the bar as provided in the regulation will not attract. But now kindly see the regulation. The local regulation, that is Andaman and Nicobar Island.
1966.
That's the one. That is the one.
Yes.
Not kindly turns to the first part of the regulation, 159.
Yes.
At page 31, Malad would find at page 31.
Yes.
Subject to the provision of section 186, an occupancy tenant may transfer any interest in his land. It's not a case now. Just one second. Malad. 2. Notwithstanding anything contained in subsection 1 or any other law for time in force. Roman 2 mechanism. Numerical 2, then Roman 2. No occupancy tenant shall have right to transfer his interest in the land if after such transfer, the total extent of land held by him will be reduced below 2 hectares. So, my lord, apparently the first appellate court gone wrong. This provision of law is in a clear terms. If I admit the plain case, then the agreement must be confined to that area so that upon a conveyance deed be executed later on, upon decree being granted, 2 hectares has to be maintained. But the entire land has been even ultimately they will not get any decree, my lord.
Yes, I've got it.
So there is no arguable case. The finding of the appellate court may not again, I'll just place that line. The appellate court says, but the consent may kindly be seen. I'll just show that finding of the appellate court again. The finding arrived at, I'll just show that now. Hello, it's page 5, last paragraph. Hence, last 3 lines. Hence, Lord, there is one thing, Lord. Had I been a signatory to sale agreement, I am stopped by my conduct. I am not a signatory to the agreement for sale. Hence, page include judgment, page 5 of the district judgment. The one which I have just read now, my lord. How the trial court went, appellate court went wrong, just to demonstrate this, I want to place this.
Yes, yes, yes.
Last third line, hence, page 5, hence, last paragraph, third line, from the bottom, page 5. Page 5, third paragraph, third
Yeah.
line from the bottom, hence. You got it?
Yes, yes.
Hence, the plea of occupancy right under section 159 of the said regulation has taken only to defend the case, which has no connection with this case, as because this is the so-called finding of the appellate court. As because the said section will only be applicable to person who has more than 2 hectares of land. So the record entry, the schedule would indicate that the entire land is more than 2 hectares. What more is required, my lord?
Yes.
There the first appellate court went wrong, my lord. This is first one. Secondly, my lord, would not find even a single scrap of paper, either relied by the plaintiff or by defendant number 2, that any single penny in the form of sale consideration under the strength of agreement for sale was given to my client. That's a different number, because I'm the owner. If the plaintiff case is accepted for a while without admitting it, then the money has passed on from plaintiff to defendant number 2. The defendant number 2 must show before the court below as well as before the first appellate court that out of this money, I have given money to the defendant number 1, Anila Soman. Where are those papers? I have not been paid with any single money. There is no concluded contract in so far as suit land is concerned. Not both court, not I have a right of enjoyment of the land. Not knows. 52 of PPE Act is also there for their rescue. But why injunction at this stage, particularly when the plaintiff could not show any prima facie case? I go with their own papers. I go with their own pleadings, Lordship. Let's go with the situation that I have no difference. Can based on these pleadings and material record, if court will ultimately grant a defeat for specific performance of contract, my impression would be no, which is subject to what my lord says. Because law, there is a total bar. So, Lordship, the first prima facie case was not there. If it is not there, the other 2 golden principles, balance of convenience and irreparable loss, would tilt in my favor, because the loss which I have sustained, Lord, I could not enjoy it. I could not improve my land. I have a right to improve my land in terms of this local regulation. My lord, kindly come to regulation.
Yes, yes, yes.
My lord, this has been curtailed now. Why? Because of the injunction order having been passed by the court below upon by the first appellate court.
Okay.
I pray not to this application may kindly be allowed, and these 2 orders has to be set aside.
Set aside.
It's fine.
Yes.
That's all.
Suit has been filed for specific performance of contract. Now, whether the land can be transferred or it cannot be transferred, can it be adjudicated at this stage? It is not the stage to adjudicate, or even a prima facie view also cannot be formed only on the basis that there is a provision, and that provision, I have a different interpretation with regard to that provision. Now, if 2 interpretations are there, can a prima facie finding can be there in order to deny injunction? I will come to that later on, Your Lordship. Thing is that 2 courts have given a concurrent finding. They have given an opinion. Whether this honorable court, without any material irregularity or illegality, can interfere with the order. Second is that the argument which has been advanced by the other side is mutually destructive. What he says, he cannot sell the property. As per the regulation, he can't sell the property. What is the injunction what we have got? Not to alienate the property. What is the problem? If he cannot sell the property, the order is not to alienate the property. There is no problem in that. There is no order whereby the court has directed the parties to maintain status quo, nature, character, and possession. That order is not there. So if you are in possession, keep on enjoying the property because you can't sell as per your own contention. So where is the problem if the court passes an order not to alienate the property? So I'm not able to understand. This goes to show what is playing in the mind of the other side. This goes to show. Because if the court passes an order not to alienate, and if he feels that he can't alienate, then challenging that order before this honorable court goes to show that he wants to alienate the property. For that reason only he has challenged. Now coming to the regulation, that part of the regulation. Now, Your Lordship. Regulation 159. I can produce at least 10 to 15 at present, meaning in the sense that tomorrow, sale deeds where occupancy right lines have been sold. There is no restriction at all. Restriction will be there if somebody has got 2.0 or 2.20 hectares, more than 2 hectares. If somebody has got more than 2 hectares of land, then in that case restriction will be applicable. Why? Because the holding should not be disturbed. Agricultural land should not be disturbed. There should not be parts of agricultural land. That is the intention of the legislature. So if suppose I have got 2.02 hectares, I can sell only 0.0 hectares. Or I can sell 2.20 hectares total. But I can't sell 1 hectare of land and keep with me 1.20. I can't do that. If I should have, by selling, I should have 2 hectares of land. And in that situation, one person should have more than 2 hectares, then only this particular provision will be applicable. I'm just reading it again. No occupancy tenant shall have the right to transfer his interest in any land. If after such transfer, there are division, means if after such, suppose I am transferring, occupancy right land can be sold. If after such transfer, the total extent of land held by him, I means something should be there with me, will be reduced below 2 hectares. Here, she has agreed to sell the entire land. So there is no circumstances that she will be possessing less than 2 hectares of land with her, because she has agreed to sell the entire land to me. So where is the bar? There is no bar at all. It's a very clear term, Your Lordship. There is no confusion in this in this particular thing. By mentioning no occupancy tenant shall have the right to transfer his interest in land if after such transfer, that means transfer is possible. As per him, occupancy right land cannot be sold. But it itself says after such transfer. Now, after such transfer, something should be there with me. If that particular thing, that land, if it is less than 2 hectares, then for the remaining part of the land, I cannot sell it. Either I have to sell the entire 2 hectares, or I have to sell that portion of land so that the remaining portion should not be less than 2 hectares. This is the meaning of it. We have number of sale deeds where it can be shown to be.
Entire property has been sold out.
Yes, I can show it tomorrow. I have many, because we have got many clients of civil nature. So I have many sales where occupancy right land total has been sold. It is permissible. But
okay.
So
and I want to see the power of attorney once.
Yes, Your Lordship.
Well,
Power has been given. That's why they have
That has
revoked.
also been revoked.
That has been
Subsequently revoked.
that is a specific thing.
you are for dependent number 2.
So attorney holder, and subsequently I was informed through a lawyer that since I have revoked it, you are therefore requested not to exercise.
That
So I
Not
think
to
not to exercise the
power to sell.
yes, power to sell.
But that
Before that, I have executed the agreement.
sale agreement has been executed before the revocation. You know,
No, that the power to execute sale deed where?
Yes, yes.
Page.
I am sure. Page number 63 it starts. 63. Now 64, clause 1.
$64.
Yes, 64,
Yeah.
clause 1.
Yeah.
Yes. To sell the scheduled property of the executant to any intending purchaser or purchases with all rights title and interest thereto at his own will and execute
Such deed
such deed
in the office of the registrar.
such deed that may be necessary for the sale of the said property and to register such deeds in the office of the registrar.
I didn't find as yet, yeah, oh, 65, page 65, clause 2,
One,
clause 1 also.
yes, to sell,
This is in continuation of 64,
Oh,
first line.
first time came.
to sell the, yes,
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 to
now
sell.
got it. Property of the execution to any intending purchaser or purchaser with right liability and whether it was registered.
No, it's notarized.
Oh, you are waiting. When I shall ask this question, then.
I can satisfy this, Honorable.
Yes, yes.
I can satisfy. This power of attorney is not required to be registered because sale deed has not been registered. If sale deed had been registered, I can understand this power of attorney also should have been registered. The sale agreement was executed. Now the sale deed has not been registered. So once if the point is regarding registration of the sale deed, then the point will come with regard to registration of power of attorney. And sale agreement is not required to be registered in the I have judgment. This honorable court has decided already. See, when sale agreement is not required to be registered in the they cannot insist that the power of attorney should be registered. Because power of attorney by its own is not creating any right, title, and interest in the property. As per section 17 of the Registration Act, it clearly says that any document which is not itself creating any right, title, and interest in a property that is not required to be registered. Neither power of attorney nor sale agreement is creating any right, title, and interest in the property. By itself,
Fair
a
contract.
future document is
Okay.
required to be executed for the purpose of this.
Okay. Never. আর সব জিজ্ঞেস করবেন প্রতিটা ওয়ার্ড The legality and propriety of the order dated of the order dated 7th January 2025 passed by the London District Judge, Andaman and Nicobar Islands in Miss Appeal number 01 of 2025 has been called in, whereby, whereby the order passed by the London Civil Judge, Joint Civil Judge, Senior Division, Port Blair, in other suit number, on an application papered under order 39 rule 1 and 2, filed in connection with other suit number 144 of 2022,
Just one.
was upheld.
I take one tablet and come out.
Yes, was upheld, comma, has been called in question in this division by invoking Article 227 of the Constitution. So, the facts that led to presentation of this present petition, which needs to be adumbrated for effective adjudication, which needs to be, needs to be stated. For the purpose of effective adjudication of this revision are that the OP number 1, OP number 1, plaintiff, defendant number 1, okay, that the petitioner, that the petitioner who happened to be the defendant number 1 in the before the London Trial Court executed one power of attorney in favor of the OP number 1 stroke defendant number, OP number 2 stroke defendant number 2, empowering him to take necessary steps to sell the suit property in favor of the intending purchaser. Purchaser or purchaser একটা or purchasers. Stop. Being so empowered, the defendant number 2 entered into an agreement of sale, agreement for sale with the petitioner for selling the alienating the suit property, and even as an advance of the consideration amount, rupees 30 lakhs was also received by the OP number 2 slash OP defendant number 2. Any time was essence of contract, any time was given that within that time the deed is required to be executed.
Just. Yes, clause 14.
Okay. And time was the essence of the contract, since it was agreed that within the time specified in the agreement, agreed by and between the parties, that within the time specified in the agreement, the sale deed would be executed. Stop. However, after expiry of the time stipulated therein, the deed has not been executed in favor of the petitioner number 2 herein, which compelled the petitioner to institute a suit seeking a degree of specific performance of contract. Along with the plaint of the said suit,
Petition is respondent number 1.
who filed the suit?
Filed.
No, we got use the word petitioner.
The
Petitioner has not filed a suit. Opposite party number 1.
OP number 1, sorry. OP number 1 has instituted, OP number 1 instituted a suit before the learned trial court, playing for a degree of specific performance of contract. Degree of specific performance of contract. Stopped. Along with the plaint and application under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure. In bracket, insert the code. The code. Was also paper. Stop. Record reveals that upon contested hearing, the said application was disposed of by passing an interim order restraining the petitioner and defendant and the OP number 2 hearing from alienating the suit property in favor of any other person. Stop. That interim order was assailed. The said interim order was assailed. Interim order was assailed by preparing one misappeal being 01 of 2025. Stop. As noticed earlier by the order impugned in the present revision, the said misappeal was dismissed, upholding the order of injunction passed by the learned trial. Stop. Mr. Joypal Lanet advocate representing the petitioner representing the petitioner submits that if the procedural for any procedural irregularity or any procedural irregularity or any illegality or non-compliance of any settled proposition of law resulted in any miscarriage of justice, law results in any miscarriage of justice in a particular litigation, this court is very much empowered under Article 227 to interfere and to pass appropriate order. Stop. He submits that here both the courts made wrong observation and both the court made wrong examination and made wrong observation and they made wrong observation came to an erroneous findings and in granting the interim order and omitted to consider that the petitioner failed to make out any prima facie case in his favor. He submits that at the time of granting an order of injunction, a court should also think as to whether the plaintiff has any possibility to get ultimate result degree or not. Possibility to get degree or not. Inviting my attention to the regulation 151 within bracket 2, Roman 2, English 2, Roman 2. He submits that these provisions has prohibited the holder of occupancy right to sell out any property more than 2 hectares. According to you?
Yes.
More than 2 hectares. Stop. He submits that the agreement for sale suggests that enter 7 hectares of land, 7 hectares of land.
It is less than 7 hectares, 0.71. The total area is 0.71. It's not even 2 hectares.
Acha, 0.2 hectares has been sold.
0.71
0.71
hectares has been sold. It is much less than 2 hectares.
has been sold out. He submits that the sale could not be effected in contravention of that regulation, and hence there was no possibility for the plaintiff to get that degree. He submits that since there was a legal bar in getting the agreement of sale enforced, the petition plaintiff had no prima facie case. And in the event, if any party to the suit fails to make out a prima facie case in his favor, then it would be automatically concluded that he has no balance of convenience and inconvenience in his favor, and he has no balance of convenience. That balance of convenience and inconvenience was not tilted in favor. Balance of convenience was not tilted in favor, and the other ingredients of irreparable injury was also not fulfilled. Ingredient of irreparable injury was also not fulfilled. Stop. Mrs. Nag, Mrs. Nag, and a senior advocate representing the respondent, representing the OP number 1, submits that submits also relied upon the regulation, the same regulation being the same regulation, that is 159 within bracket 2 তারপর আবার 2 of the regulation such and such নামটা লিখে দেবেন হ্যাঁ of Andaman and Nicobar land regulation 1966 ওটা লিখে দেবেন হ্যাঁ submits that such regulation applicable for the holder of the occupancy right having land of more than 2 hectares. And in the present case, the said regulation cannot come into operation. Inviting my attention to the relevant clause of the power of attorney, she submits that the power of attorney holder was categorically empowered to sell the land to the intending purchaser, and he submits that after execution of this agreement of sale, the who is the OP number 1? No, the petitioner. Sorry, petitioner has executed power of attorney in favor of another person, empowering him to sell the same piece of land. Him to sell the same piece of land. Stop. Miss Jinu, landed advocate representing the OP number 2, submits that the original power of attorney has been revoked. Attorney has been revoked. Informs the court that original power of attorney has been revoked.
After the execution of the sale.
Huh?
After the execution of the
After
sale.
the execution of
The sale.
agreement for sale, submits that the original power of attorney has been revoked after the execution of agreement for sale. Stop. এবার আমার টাই না had the learned advocate peruse the materials on the stop. Needless to observe that while granting the ad interim injunction or granting the order of injunction, the court must follow the settled principle of law, and court shall look into the aspect as to whether the party seeking such injunction has made out a prima facie case in his favor, and court will also aspect the other 2 ingredients, a balance of convenience and irreparability. 2 ingredients say the balance of convenience and the irreparable loss. Stop. Now, it is now to ascertain as to whether the such party has got a prima facie case in favor, the court will primarily inquire as to whether that party has been able to raise any substantial question. আমি শুনুন, don't yesterday I have stated it. You have developed a habit. We are thinking. You are taking dictation. We are thinking. কি বললাম? As to whether he has raised any substantial cost requiring the court to go into the trial. And if injunction is as sought for is refused, and subsequently he succeeds in appeal, whether he shall be compensated or not. Similarly, if injunction is granted but plaintiff suffers defeat in the suit, whether the defendant can be compensated or not. In the given case, prima facie material has come that the petitioner executed one power of attorney empowering the OP number 1 to OP number 2 to sell the suit property. And being so empowered, the OP number 2 entered into an agreement for sale with the petitioner. OP number 2 have entered into an agreement for sale with the petitioner. OP number 1. Plenty. And as submitted on behalf of defendant number 2, you have received the money. Admitted. Defendant number 2 has received as submitted that that defendant number 2 defendant number 2 received rupees 330 lakhs as advance of the consideration amount from the OP number 1. Now, whether due to whether the regulation 159 within bracket 2 Roman 2 will stand in the way in execution of the sale deed and in completion of the transfer or not, certainly be decided at the time of trial. Now, at this stage, court tentatively will look as to whether one prima facie material has been brought on record to lead the court to go into the trial or not. Court to go into the trial. So one power of attorney has been placed for power of attorney, as well as the agreement for sale have been brought for prima facie consideration of the court. And it is also brought on record that the occupancy, that the holder of the occupancy tenancy, but that the owner has executed power of attorney in favor of another person. So if during pendency of the trial any third party interest is created over in the land in question, should land, the same can lead multiplicity of proceedings. Okay. Same can lead multiplicity of proceedings. And if it is happened that if it is allowed to be happen, the OP number 1, being the plaintiff before the learned trial court, shall suffer irreparable loss and injury which cannot be compensated in terms of money. Which cannot be compensated in terms of money. Considering all this aspect, we have of the view that the plaintiff before the learned court below has made out. I am of the view that I am of the view that the plaintiff made out a good prima facie case in his or her, in his favor, and hence the learned court below has rightly passed the interim order with a view to preserve the property as it was on the date of presentation of the suit. With a view to preserve the property as it was on the date of presentation of the suit. And as a result, it is also held the learned appeal court has correctly affirmed the trial court decision. Yes. Huh? Acha. After passing the order, Mr. Joypal made it clear that the direction be given upon the learned trial court to expedite upon the learned trial court to expedite the disposal of the suit. Mrs. Nag did not raise such objection in view thereof, though this court has no knowledge about the condition of the docket of the learned court below. This court has got no knowledge regarding the condition of the docket of the learned court below. Yet the learned court below, yet I am inclined to make a request to the learned court below to make an effort, sincere effort to dispose of the trial as expeditiously as possible. As expeditiously as possible. Oh, I mean, I say,
the observation in this order.
Needless to observe that
It's all tentative.
these observations are tentative in nature, and those have been made only for the purpose of disposal of this instant application. And the trial court shall proceed without being influenced by any of these observations made herein above. Yes.
This I can start today. This paper book is ready, second appeal.
And for the respondent.
Yes.
It takes up essay 3, essay 2.
As it took.
I'll just start in formally today and I'll request this book tomorrow. I'll just start.
So do it.
But I'm practice.
In the meantime, I shall read it.
Mal.
If you do it, then I can read. And if you play adjournment, then my reading will be
Done in this.
unnecessary. Okay. So get ready and do it. Mrs. Nag,
Yes,
so I shall take the brief and read.
Your Lordship.
So do it on that day.
Yes, Your Lordship.
Yeah.
Positive.
3 and no, 10 and 11. Yes.
Yes, positive will keep it up.
Yes.
Next.
Huh? Fifth. পাঠিয়ে দেবেন তো?
Pending here, huh? I am for the this appellant. Has been served the injunction.
Your maybe any of your learned friend. Take information. I am adjourning for the day.
Here,
5th. It would be 5th or 6th. 6. Oh. Next also I am next item number 13.
here.
39 is appear.
I am for the appellant.
I know your other side.
Again, the same situation.
So inform. You ask your junior to inform. On 6th it will be taken up for you.
I'm filing the paper
Hey, paper.
in Abhilash channel. Item number 30.
এই
And
শো-
finally, I already given the copy.
হ্যাঁ, হ্যাঁ,
Already given.
you sent only the paper. When paper book has been filed, no other documents required to be sent, only paper. Yes. 14,
Your Lordship, I am for the appellant, Your Lordship. Lordship, this matter my senior Mr. Arul Prasad for the respondent, Your Lordship. Take an answer information on next week, Your Lordship.
will you do it on the next day? Monday we shall celebrate Saraswati Puja, you will take it from us.
Your Lordship.
Okay, so 5th,
Interim order be extended. Interim
oh,
order.
intimated expired due date.
No, Your Lordship, it has expired. But Your
So
Lordship,
it's,
as other side is speaking, I thought that the matter will be taken up for hearing today and we can finish it up.
intimated when?
Your Lordship, the prayer was not made.
Oh, boy, yeah,
Not
30th September 2023. What is your submission? Is one reinstatement of the interim order expired
Objection.
with objection? And in action. An adjournment has been sought for on behalf of the respondents. Today, top. Acha. Mrs. Naglan, a senior advocate, pays for reinstatement of the interim order granted by an order dated, second appeal.
Second appeal, Your Lordship.
An order dated 18th August 2023. He submit that. Why it has not been prepared for extension?
Mistake of the council.
Huh?
Mistake of the council. Due to inadvertence, it happened.
She submits that the file was misplaced. However, recently it has been located in her chamber. And due to this reason, the prayer for extension of that interim order could not be made. ঠিক আছে, learned advocate representing the respondent did not seriously oppose. আচ্ছা, কেটে দিন, seriously opposite, oppose such prayer, opposes such prayer, stop. However, having heard the learned advocate and upon perusal of the record, I am of the view that there is no change of circumstances. And there is no change of circumstances. ঠিক আছে? Considering our aspect, I am inclined to reinstate the interim order granted by the honorable, reinstate the interim order
25th July 2023.
passed on 25th July 2023 and to extend the same till the disposal of the appeal.
That is better, Your Lordship. Otherwise, again, the. Your Lordship.
So shall I record you have given consent?
No, no, she will be in problem.
আচ্ছা, extended till the disposal of the appeal.
Yes, deeply
ঠিক
object.
আছে? Leaves the matter for further consideration on 5th. Okay. Next,
Your Lordship, I am for the petitioner. Respondent.
Yeah.
You see.
so 7th.
7th.
Seventh. Yes,
Item 16,
For the respondent, no? Can I do it? Next week.
Appearing for an effective consent. It's a complaint case for the complaint. For the representative.
have you served?
Yes. Matter is pending from a reasonable period.
So not today? Not today? You ask your junior to give an intimation. 17,
Item 17, my lord, I am appealing for, now, this matter, my lord, it can be taken up for hearing.
okay.
Lordship, bring the next week, Lordship, it is under prevention of corruption. Discharge application was filed by the accused person. That
Discharge,
was discharge, 227, was rejected by the session
Against
judge.
that, I am-
Against that,
Oh, 227 rejected, 228 the court proceeded
Yes.
to frame charge.
not for framing of charge,
Fix the date for
Framing of
framing of
And there
charge.
is an interim order passed by this court.
and it will take time, Lordship. Under
No, I-
Prevention of Corruption Act, Lordship,
My lord,
I have to given some time.
my lord,
Whether there was a sufficient material to frame the charge or not,
Lordship, there-
only consideration.
Lordship, there was
Okay,
next week, Lordship.
interim order is there, staying up all proceedings or further proceedings.
Whatever next week I will.
Interim order will expire when? Today.
up to this month interim order was.
Acha. An adjournment has been paid for on behalf of Mr. On behalf of the state. ঠিক আছে? Stop. Though Mr. Kumar, an advocate for the petitioner is present. Stop. Acha. In view thereof, leaves the matter for further consideration on 5th. Tell, what?
Next week, any date, Lordship.
So the matter stand adjourned for the day. The matter stand adjourned for the day. Stop. An interim order passed earlier in the earlier is extended till the end of January.
February, my lord, today we are.
Oh, acha, till the end of February or until further order, whichever is earlier.
Lord, get
Hmm.
okay.
Your Lordship, in this matter, my senior address for the repetition, Your Lordship.
Up to private respondent, my lord.
Eh?
Opposite affidavit in opposition to it,
Yeah,
serving the copy.
okay. So will you file reply?
Yes, my lord.
The affidavit in opposition, have you filed in court or in the department? Acha, yeah. What is your name, please?
Varsha.
Acha. Mrs. Shah, learned advocate, informs that the affidavit in opposition has already been filed. Informs that the affidavit in opposition has already been filed on behalf of the respondent in the department. Stop. Acha, he served the copy of that opposition to the learned advocate appearing for the petitioner. Has given copy to you? He is giving. When?
Supposed to file
Acha. Acha, stop. Acha. Stop. Mr. Sachansa ওনার নাম লিখে দিন। Mr. Sachansa pays for leave. Give your name. Pays for leave to file affidavit in reply. Stop. Acha. Now let such affidavit in reply be filed within.
Your Lordship, the mistake has been committed by us on the Your Lordship, which ought to be of affidavit in reply. So everything is the affidavits.
তাহলে কেটে দিন। তাহলে you are appearing for the petitioner.
Your Lordship.
So you are saying affidavit in opposition, কেটে দিন পুরো।
So the
হ্যাঁ।
mistake has been committed, typographic.
আচ্ছা, Mrs. Saha, learned advocate representing the petitioner submits that affidavit in reply has already filed in the department. Stop. Acha, a copy of the same has been handed over to the learned advocate representing the. Oh. And a copy of the same has already been has already been handed over to the. তাহলে কি দরকার? You have pray for time to file affidavit in reply.
The matter is completed, Your Lordship, affidavit exceed all completed, the matter is.
Affidavit in reply is also there. It is affidavit in opposition, but he didn't file affidavit in reply.
It has been completed today. Affidavit in reply should be.
Oh,
Sorry, Your Lordship. I'm sorry, I may be permitted to, leave may be granted, Your Lordship. Correct.
আচ্ছা। তাহলে এটাও কেটে দিন। Where is the affidavit in opposition that is not with the record? Yes. Acha, record shows that the affidavit has already been exchanged by the parties and the matter is ready for hearing. So when?
Next week, 6 or 7.
Actually, in view thereof, list the matter for final hearing on 7th. Okay?
I don't Wednesday, the
Hmm. Next.
Automatic and the one of content.
If you have village. I was on the notion that today is fixed for hearing. I've been told by my learned junior at the time, I was required to file my informal paper. So I just need an extension for.
Have you annexed the year lower court record, yes, such and such evidence?
Report was found for. Not a good people with the entire thing with my.
Direction was given,
File
eh?
informal paper.
No such direction, for filing improper proof, learned advocate 6-1 was done.
Even 1 week time.
Acha, yeah, I will Ms. Jino learned advocate representing the appellant case for extension of time to file paper book, to file informal paper book. ঠিক আছে? So time to file the informal paper book is extended for a further period of 1 week. Again, you will take time. As 2 weeks. With a copy to the learned advocate.
Insurance company.
Acha, with a copy to Mr. Khan. Yeah. Where is the owner? Owner has not come.
That is there, affidavit of the service of there. I already saw it.
Whether they contested before the real court. Acha, our Mr. Khan who has entered into appearance on Khan who has entered into appearance for the respondent / insurance company. Stop. I have been informed that the respondent number that the owner stroke respondent number 1 has not contested.
Oh, yes, because I was.
Contested. So serve him. Paper book.
So, I saw the appeal copy. But they did not use so clearly.
সেদিন আর কিছু লিখতে হবে না, ওনার আসেনি তো কি করবো, ঠিক আছে? আচ্ছা, লিঙ্কস দ্য ম্যাটার আচ্ছা আফটার 2 weeks in the next available circuit bench, ঠিক আছে, কমা subject to his convenience.
No, there is matters which has been.
ও Passover, হ্যাঁ।
Lord, I am for the respondents, my lord. Your lordship has, I have taken time for taking instruction, my lord. On instruction, I am submitting, my lord.
On earlier occasion also you take instruction.
This is the second time.
For a brief accommodation on 29th January.
Yes,
You
my lord. Thereafter, today, the matter has.
So when you will do it?
My lord, I have taken instruction, my lord.
Have taken, yes. What do you want in this matter? Your map.
Yes, for sketch map, my lord, it requires.
Supply him if.
My lord, for supplying, before that, my lord, a field inspection has to be done, my lord, because the actual physical position of the tenant has to be seen. my lord.
Ascertain.
Yes, it has to be ascertained first. Thereafter, the area patwari will submit a report before the tehsildar concern, and after going through the report, because before issuance of a map, my lord, the actual possession of that tenant.
How much time you require?
Issue the map.
How much time you require to complete the entire process?
It is 3 months.
3 months. Madam.
Are you agree?
3 months.
2 months.
Simple.
The present petition has been preferred paying for a writ of mandamus directing the respondent number 2 to issue sketch map in respect of the land bearing survey number 8/P, measuring an area of 0.5000 hectares situated at Sippighat village, under Port Blair Tehsil district, South Andaman. Stop. Learned advocate defending the Mr. G. Mini. Miss G. Mini, learned advocate defending the petitioner submit that the land, particulars of which referred in the foregoing paragraphs, were settled in your favor. Now,
License was issued in my favor.
huh?
License was issued in my favor.
Acha,
And recordability also given to me.
Acha, license was issued in the above, comma, yeah, license was given in respect of the said land. Occupancy right. Acha, occupancy right, acha. And his name was also recorded in land revenue records. Land revenue records. Stop. Acha, he's.
It's non-occupancy, my lord,
Huh?
your lordship, non-occupancy. It's not occupancy, right? It's non-occupancy.
Why the land license was given?
License was given.
Yes. To possess and enjoy the said land.
Yes, but
ঠিক আছে?
the occupancy has to be deleted.
As per the terms and condition contained in the instrument of license.
My lord.
I am correct or not? Huh? Okay, I am not islander, you are. So assist me.
License was given in respect of said land.
To possess and enjoy the same as per the term and condition contained in the instrument of license. Okay. Acha. And his name was also accordingly recorded in
Record of rights.
the relevant land revenue records. Acha, stop. He submits that
Page 18, my lord.
that to avoid any confusion regarding demarcation of that said land, the petitioner, by making an application, made a pair before the concerned Tahsildar to provide a survey map of that land. Stop.
Sketch map.
Of the sketch map of the said land, but despite sketch map, survey map ta to kete diya holo. Sketch map of the said land, but since despite receiving of such application, the same was left unattended, comma, the writ petitioner was compelled to prefer this writ petition. Stop. Acha. Miss Das, learned advocate defending the petitioners, submits, comma, upon instruction that before issuance of the sketch map before providing such sketch map to the as paid for by the petitioner, inspection. Physical field inspection of the land in
Has to be
question
carried
is
out
required.
for actual.
Before issuance of the license, everything was done, thereafter only the authority. has
These
given
are the left
license.
out cases, my lord.
Okay.
This is left out cases, my lord. This is not a left out case.
The sketch map is different, my lord. License. is
Okay,
different.
I am recording his hard submission. Acha, yeah. Of the land in question is required to ascertain the actual possession of the present.
Actual physical possession
Actual physical possession of the present petition.
of the tenant.
Stop. Acha. In reply, Ms. Mini submit that before granting license, physical inspection was made and all other connected formalities were observed. and no further physical inspection is required. Stop. However, however, having heard the learned advocate on record and upon perusal of record, materials on record placed before me, stop. I am of the view that to avoid any future complication, it would be appropriate to allow the concerned respondent to hold physical field inspection before issuance the sketch map. Stop. So that in view thereof, the writ petition is directed to is disposed of directing the respondent number 2 to again, shall I say again, shall I give direct order
No, my lord.
to consider the
When the license is there.
No, my lord.
the
that has to be
consider the
considered.
prayer for provision of provision of sketch map in respect of the subject land after completion of field inspection. ঠিক আছে? And it is made clear that the such field inspection and decision regarding making a supply of sketch map shall be carried out within 2 months from date. It is made clear that the such period is preemptory. ঠিক আছে? With this observation and order, this writ petition is thus disposed of, however, without any order as to the cost. Next.
I'm for the respondents.
This petitioner, my lord, he has filed an application before the authority under section 161 of the regulation. Because, my lord, here, the adjacent plot holder, he has started encroaching my land. So I have given a representation to the Tahsildar, who is the appropriate authority, to reinstate the land. That application is still pending. It was given on 19/6/2023. Kindly be seen at page 30, my lord. Have a next. My lord, this has to be disposed of within a certain time, my lord. I am the recorded tenant.
Yes.
My lord, first of all, my lord, the respondent against whom the respondent means the
Private respondent is there. Have you served?
private respondent is not there. She has not made the Jasuda Sarkar as a private respondent to this party because she is asking relief against the Jasuda Sarkar.
My lord, before passing the any relief against by the Tahsildar, Tahsildar can give
No, my lord.
hearing opportunity.
No, you may.
This application is not at all maintainable.
Let me submit, my lord.
Let her submit.
Before passing any order, my lord, the Tahsildar can very well given opportunity to all the parties, my lord. That can be.
You make him party. Main allegation is directed against the private respondent. Okay. No, again, not against the transgender. The action actually started by that person. Then you have come that I brought this action to the notice of the Tahsildar. Tahsildar has not taken any step. Okay. So are you arguing in this point that his presence is not required?
My lord, at the time of
Okay.
order by the Tehsildar, my lord.
So I am going to dismiss for non-joiner of necessary parties. Non-joiner of necessary parties is fatal. You will bring a serious allegation against the person concerned without making him party.
My grievance.
Acha, leave is granted. No, not, it is not proper thinking. You have to bring him party. Be fair and come in the court with clean hand. That I have this allegation against you and hence I am going to court.
My lord, I'll include, my lord. I'll include that
As paid for, on behalf of the petitioner, comma, leave is granted. Leave is granted to may implead the person against whom the allegation of encroachment of the petitioner land is directed. You notice? Acha. You make party, acha.
I serve the copy.
Stop. A copy of the writ petition along with all annexures thereto must be served upon him. And affidavit of service. Acha. Showing affidavit, an affidavit showing service of that copy must be filed on the returnable date.
And if we showing service of,
Within 6, it will be.
showing service of,
List the matter for further consideration on 6. Next. Showing service of a copy of the writ petition upon the person so impleaded. Upon the person, upon that person must be filed. That person must be filed. ওপরে লিখেছি against whom the allegation of encroachment of the petitioner last in directed. ঠিক আছে?
বললেন I paid for on behalf of the petitioner who is granted to include the person against whom allegation of
Encroachment of the petitioner land is directed. Stop.
a copy of the
A copy of the writ petition
along with
along with a copy of the writ petition along with all annexures thereto shall be served upon him,
must be served.
him or her, upon her, ঠিক আছে, and affidavit of service shall be affidavit of service should be, and affidavit of service shall be filed on the returnable date. ঠিক আছে,
These 5 matters, leave has been granted by the court.
Okay, I am coming at 2 or 2:10.
Hardly take 5 minutes lunch.
Okay, I am coming. Okay. You enjoy the recess? Okay.
whenever administration takes any decision, it should not be in a haste manner first. Secondly, there has to be a reasoning. Now, this is one of such case. Well, I'll show the impugn order once. Page 16, Lord, kindly come here. 60. 60. This is for the third time I'm coming before this court. But kindly see, order is dated 29 January 2025 at the top. Not would find. It's an illegible copy because it is pasted today morning. Now kindly see 61. It was pasted today early morning, 61 last paragraph. In view of the above, I hereby order that the petitioner shall be remove his shop set up illegally under the space meant for staircase within 2 days from the date of this order, failing which the executive engineer works is directed to execute the order at the cost of petition and report compliance. Now, first of all, this order has to be set aside on the ground that it has been passed in a very haste manner without allowing the writ petitioner to take recourse of law, particularly when the coordinate bench twice set aside this type of order. I'll show that order. Same order set aside. Now, kindly turn to page 56. Page 50, same order by the same authority, Secretary Municipal Council. What would see? It's order dated 24 July 2023. Same reasoning. This order was challenged. One would find at page 57. This order was challenged at page 58. I've been asked to remove page 58. All these matters were heard analogously, and one of these orders were challenged. In all the cases, the order carries a different date, but the same nature of order. I'm running a betel nut shop, not shop, under the Port Blair Municipal Complex. There is a resolution taken by the Port Blair Municipal Council in terms of the municipal regulation to allot the shop. That was not done. I'm not having a big business, a small betel nut shop for my survival. Resolution has been taken. Council have taken. Municipality means it's an elected body that takes a decision in a meeting. Yes, this has to be allotted.
In his favor.
In all the petitioners' favor, it was ignored. Orders are being passed for my removal, one after other. This court heavily at page 58, will not kindly see.
Petitioners, that means how many petitioners?
In these, there are other petitions also, Lord. The next matters.
Yes.
Same. Order date is same.
All are running.
Adjacent shop, small pawn shop. One is in a handicap quota, allotments were proposed to be done. Page 58 may kindly be seen. The last order of the High Court. I'll show the first order of the High Court also. Not page 59 may kindly be seen. The grievance of the petitioner is direct against an order dated 24 July 2023, which I've shown just now, Lord, which is at page 56. Passed by the office of the Port Blair Municipal Council. Port Blair inter alia concluding the petitions are in illegal occupation of staircase of the subject premises and causing health hazard. On behalf of the petitioner, it is contended that by an earlier resolution dated 29 May 2013, the petitioner was allowed to occupy a space in the subject premises. The impugned recommendation is without reason and is drastic to the extent that it is not only declares the petitions to be illegal enclosure, but also declares that there is a health hazard being caused to the operation of petitions. Significantly, the petitioners are running small shop and were prima facie recommended for space at the subject premises. In view of the above, the Secretary Port Blair Municipal Council is directed to take a decision, fresh decision in the above matter after giving a right of hearing to the petitioner. It is made clear that there has no expression on the merits of the case, and the council is to consider the case of the petitioner in terms of an earlier order dated 21 February 2023 passed by a coordinate bench in WPA number 120. I'll show that also. In view of the other impugned order has been set aside. Malad, kindly see. The order dated 24 July 2024 has been set aside on the ground that it contains no reasoning. If Malad compares page 56 with the impugned order, one which I've challenged now, same reasoning. The other 2-3 paragraphs are lesser in the present impugned order. Same reasoning. And Malad, kindly see, when High Court have intervened in the matter, you have been asked to pass an order. Why? Well, heaven is not going to fall. 29, you passes an order, paste it today early morning, not the client have rushed to my office today morning. I immediately prepared it. So only I have sought leave because today, 2 days expires today. But today they have already, the men have gathered. The infrastructure have been brought in by the Secretary Municipal Council to demolish the shop room. Because 29 order which I have challenged, it gives 2 days time. From date of order, that kindly see the intention. 61 says 2 days from the date of this order. But the order was pasted today morning. Why 2 days, my lord? No, I have a remedy. I have a right to challenge this. Particularly when two coordinate bench have set aside the previous order, identical order, same order, in favor of the petitioner. I'm running a shop. There is a recommendation you have not implementing.
Where is that recommendation?
My lord, I'll show that.
On earlier first occasion, WPA 119 of 2023 was passed, directing the authority concerned to consider your application for allotment of shop.
Yes, I'll show that order also.
That.
My lord, kindly see page 55. Page 55. The secretary says that I have not made an application. This is an application for allotment of shop. Kindly see, my lord, by the writ petitioner. It was received by the council. And my lord, kindly see page 61 again. What secretary says? Secretary says, but page 61,
It is your application.
yes, in terms of the direction of the High Court. What the secretary now says that I have not applied it while rejecting my claim. Now kindly see page 61. Page 61, 7th paragraph from the top. 61, 7th paragraph from the top, impugned order. 7th paragraph. It's a small paragraph. Page 61.
61.
61.
Yes.
It is 7th paragraph. No? It is small paragraph. It is pertinent to mention that the petitioner has not applied for any lawful shop in the SVPMC. That is Sri Vijayapuram Public Port Blair Municipal Council. Moreover, SPVM does not have any vacant lawful shop for allotment of vegetable market in Monpura. How this can be? Identical situated person were given allotment order. I have annexed with this petition. There is a class discrimination, Lord. But what I pray, I'll issue a notice to the respondents. But there is an extreme urgency, Lord. The order needs to be stayed for its operation for a limited period. Otherwise, they would demolish my land. There are two orders of the court, my lord. One order by Justice Nizamuddin, as my lord was then. I'll show that order also. Second by Justice Kapoor Sahab. The first order, my lord, would be at page 62, page 52. By His Lordship, Honorable Justice Nizamuddin, as my lord was then.
Have you got the resolution 2013 annexed to you?
Yes, yes. It's right from page, I'll just show, my lord. Page 23. Page 23. And the court have accepted it, not this coordinate bench have accepted it, that there is a resolution.
It's a municipal building.
No, it's a building being owned by Port Blair Municipal Council. I'm a tenant. I'm running a shop. I was allowed to occupy it. I'm occupying, I was paying rent. Now they want to remove it on the ground that it's within the staircase. But identical shop where allotted, I'll show that document, Lordship. Just 1 second. Just 1 second. My lord, it's page 48. Kindly see. My other shop owners, same grievance, it has been allowed. Not see, page 48, it's in the name of one Marimuthu. In that case, it was considered. In my case, they say that application has not been made. My lord would see, as per the decision of the council in its meeting held on 29/4/2023 and on payment of so-and-so, see A. Marimuthu, son of so-and-so, residence of so-and-so, being reserved price fixed by council for vacant space / room. So vacant space / room is been allotted in the MG market.
Okay. Awesome. Leave granted to the petitioner to move this application on urgent basis and the service upon the respondent is dispensed with invoking rule 26 of the appellate schedule. Stop. Mr. Joypal, learned advocate, representing the petitioner, submits that by an order dated 29th January 2024, 5, the petitioner has been directed to remove his shop as set up under the shop from the municipal building, from the building of municipal collection.
It's vegetable market, page 61 may kindly be seen, 61, first paragraph. Sri Ganeshan has enclosed a space under the staircase of vegetable market at Monpura. Vegetable market at Monpura.
From the shop located at vegetable market at Monpura. He submits that it is expected that an authority will not act in hottest manner, and the authority will while dealing with but in compliance with the direction, while complying with the direction of the Honorable Court, will decide any issue by passing a reasoning order. He submits by the order under challenge in the petition, the order under challenge by the order under challenge in the petition is a cryptic order, and he invited my attention to an order passed by a coordinate bench in
Page 58.
in a batch of writ petition on 25th September 2024, a order of similar nature was set aside with a further direction upon the concerned respondent to take fresh decision. He submits that the municipal corporation, by adopting one resolution on 29th May 2013, resolved to allot the safe space in favor of the petitioner, and even based on such resolution, allotment has been made in favor of one similarly situated person also.
Right.
He submit that such action on the part of the respondents is honest in the eye of law. He plays for stay of operation of the order. Stop. Record shows that the concerned municipal corporation adopted a resolution on 2013 and decided to collect rain from the present petitioner, and it is also apparent from the record that as per the decision of the council taken in its meeting held on 29th April 2013, upon payment of certain amount of money, an agreement bond was allowed to be executed by an identically circumstanced person. So, and admittedly, the order impugned has been passed on 29th January 2024, 5, giving only 2 days time to the petitioner to remove their their stalls, which prima facie shows that the government, that the respondents have acted in hottest manner. And having heard the learned advocate representing the petitioner and upon considering of the materials of record, I am of the view that a good arguable case has been made out in this petition, and until the order under challenge, operation of the order under challenge in this petition is stayed, the petitioner will suffer irreversible injury. Stopped in view thereof, I am inclined to grant a limited stay of operation of the order dated
29 January
29th January 2024. Stop.
25.
Let the operation of the order dated 29th January 2024 25 passed by the Secretary, Sri Vijayapuram Municipal Council be stayed till 7th February 2025 or until further order whichever is earlier. Stop. Mr. Joypal, Mr. Joypal, the petitioner is directed to serve the copy upon the respondent.
Both the respondent.
Upon the respondent. In the meantime, and file list the matter for further consideration at the top of the list on 7th আর এটা তাহলে যে 6th নাকি 6th on 6th February 2024. ঠিক আছে?
May I get a plain copy because today being the deadline.
A plain copy of this order may be provided to the learned advocate representing the petitioner with a liberty to communicate the same to the concerned respondent, who is directed to act on the basis of such communication. ঠিক আছে?
All
are same.
But item number 4, the place of shop would be different. That's the Monpura market. It's a handicap market. Item number 7.
Only handicap.
Handicap market at Monpura.
Handicapped market.
It's a vegetable market. It's a handicap market. 7. Item number 4.
Monpura. ঠিক আছে? Okay.
I'm grateful.
Hmm.
I'm grateful.